tech companies are obviously in the information business. Sometimes they want you to have it. Sometimes they don't. Sometimes they want the court to have it. Sometimes they don't. Sometimes, a lot of the time, they get their way. Here to talk about those issues now with us is Alison Frankel. Alison writes the On the Case blog for Westlaw Next Practitioner Insights. I read it regularly. It is on my RSS feed, but a lot of interesting cases come through there. She's a long-term reporter on legal issues, and she joins us now. Alison, thanks for coming on the program.
Thanks for having me, RJ.
So listen, you wrote recently about Amazon, the FTC, and the dark art of corporate secrecy in court. What was that about?
Broadly speaking, it's about how corporations, litigants generally, but corporations in particular, have been able to persuade judges not to make court records publicly accessible as they are supposed to be. This goes back all the way to English common law, way back before there even was a United States of America, that courts are supposed to be open. People are supposed to be able to see what happens in court. But increasingly in the last 20 years, corporations have been able to have records sealed, sometimes because they claim corporate secrets are at stake, and sometimes because they claim their intellectual property is at stake. But increasingly, no one is really testing whether their claims are legitimate. So would you like me to discuss?
No. I was just going to jump in for a second and say that, it seems that when you're talking about a fundamental principle, to me, freedom or transparency in the court system, it's a very fundamental principle of a free people. It's not even just a legal principle. It's kind of a societal principle. That's why, when we talk about star chambers or secret proceedings or trial in secret, that's supposed to be the hallmark of an unfree society. So it would seem to me that anyone who wants, certainly could be legitimate cases where you'd want certain records sealed, but it seems to me the burden of proof would have to be very heavily on the side of the party that wants to conceal information from the public. But you wrote about, in this particular case, about a Federal Trade Commission case against Amazon, where it seemed, and maybe you can tell us more about it, but it seemed as if that may be an example, perhaps one of many, where that burden of proof was not really asked or met.
Well, they did have to. They did have to file basically a request with the court to ask that records be sealed. But what happened there was the FTC didn't really put up much of a fight. The two sides, Amazon and the FTC, and just to put this in context, the FTC was investigating allegations that Amazon set up a system whereby children who were playing games their parents had downloaded onto Amazon tablets would be induced to pay actual money for, cans of gold stars in order to play these games on these apps, which were downloaded for free. So basically, and Amazon wasn't alone in this. Other companies had similar programs, but basically, children would be paying real money for apps that were supposed to play apps that were supposed to be free, and parents didn't necessarily realize it when it was happening. So,
and the judge determined, I'm sorry to interrupt, Alison, but I just wanted to explain, or ask you, the judge determined, first of all, he quoted a boatload of the kids bought, and quoting the judge's decision from your article, a boatload of donuts, a can of stars, and bars of gold. And my reaction was, I want that. But, it sounds like fun. But and of course, that's the point. But he determined that Amazon was, in fact, liable, and And what was his thinking there? I'm just intrigued. What was his reasoning?
his thinking was that that customers had been deceived, customers had been misled, and Amazon has basically dismantled the program. So, there is a tacit recognition by the company that this was not a great a great service they were providing to their customers. But my point was that this was a matter of some public interest, I would say, and yet the judge basically said, well, Amazon tells me these documents are of competitive importance, so I'll just let them stay under seal. I'm of course summarizing, but basically that's what happened. And the only reason we know that a lot of the documents that were under seal weren't really of any competitive significance were because the judge did a clumsy job of redacting, so people were able to cut and paste the order finding Amazon liable and see what exactly he sealed. And a lot of what was sealed was just embarrassing. It was Amazon referring to parents of young children as low-hanging fruit, which is not a description I think those customers would like to see. And the company describing the reaction from customers demanding refunds as a burning house. That's not information that's of competitive importance. That's
right.
Not the sort of thing that should be sealed.
It's just information that is embarrassing to Amazon because it doesn't make them look like nice people. And
exactly.
Yeah.
Exactly.
So it's interesting, first of all, so clearly Amazon had to disable these apps, which I guess means I have to go to the Star store now to get my can of stars. But look, it sounds like what intrigues me about this, it's a couple things, Alison Frankel. One is it sounds like the judge did the right thing, as I would perceive it based on my limited knowledge of the case, that he did hold Amazon liable for what was not a good thing for it to do, and that was just right and just and proper. So it's almost like rather than going at me, for example, criticizing the judge is like he's a bad judge. I mean, he seems to be a reasonable judge, but in that sense, but it seems like the real takeaway of your story, and what I think is so important about it, is that it's almost normative now. It's almost, well, if they don't want it out, I won't put it out, as opposed to, and if the other party doesn't object, then fine, I'll seal it, as opposed to, as a member of the legal profession, as a judge, I bet there better be a compelling reason to keep it secret, or it should be open to the public. Did you get what I'm saying? Does that make sense?
Yeah, no, absolutely. I think you're right. We can't criticize this judge for not taking the case seriously and not considering the public's interest. He did definitely consider the public's interest in being protected from deception in these apps, but where I think he fell short, and a lot of commentary on this particular decision thinks he fell short, is that he didn't keep the same eye towards the public interest in terms of information and access. And yeah, judges are really busy. Federal judges have huge dockets, and they're dealing with criminal cases, and the FTC wasn't putting up a fight to get these documents out into the public domain. So it is, as you said, this is standard operating procedure. There's a federal magistrate in Houston who's done a lot of writing about secrecy, and he just came out with a piece, actually just today, at a site called justsecurity.org, about our U.S. courts going dark. And he wrote about, secret courts, the Foreign Intelligence Surveillance Court, and a lot of the intelligence secrecy that's been mandated in the last year since 9/11. But he also wrote about he also wrote about these sealing motions on civil dockets, and pointed out that more and more we just don't even know this is happening because
Right.
no one's standing up to say unseal this document, unseal this record. In the MetLife case, the too big to fail case,
Right.
the organization Better Markets put up a big fight over the percentage of that docket that was sealed. At one point, it was something like 2/3 of the docket was sealed, and this was in the test case over a major financial reform.
Right.
And
Right. An issue that could affect the future of the global economy, conceivably, if it, in fact, as it was, I believe it was held that MetLife was too big to fail. Is that correct?
Actually, no. It was the opposite. The judge found that they'd been improperly designated as too big to fail. But the point that Better Markets was making in protesting the sealing was, how can we have faith in any ruling the court delivers if the public doesn't have a chance to understand the underpinnings? And that's a gigantic case, and I doubt anyone but historians would really want to read the hundreds of thousands of documents in the record. But the point is the same, whether it's a million document record or it's a much smaller case. Openness provides legitimacy.
Right. And it's fundamental to knowing that your court system is working on your behalf as a citizen. I think, by the way, in the MetLife case, of course, I was wrong. I think what sparked my thinking was I think they were leveraged for more than Lehman Brothers, which was clearly a systemically important institution.
Yeah.
So I think I was, I still have not fully absorbed the impact of that decision. But let's talk about technology companies again for a second, Alison Frankel. Here, in this case, they've been trying to keep information secret, and I would certainly argue against the public interest in this case. But there have been other cases where they've been trying to keep the public secret, and they've been praised by a lot of folks, including to a certain extent me, as heroes for it. That in effect, the government should not have an open. I'm thinking of their refusal en masse, at least in certain cases, to turn over their records in large bulk to the government without proper authority being displayed on the government's part. The issue of Apple and the iPhone and keeping that secure and not opening it up for the FBI and all that sort of thing. How do we square those two? One where I would argue they're somewhat on the forces of light, and one where maybe they're on the forces of darkness or concealment. How do those two fit together in your observation?
It's a really good question, and it's true that certainly in the last several months we've seen, and going back a few years, we've seen Apple in the cell phone unlocking cases. We've seen Microsoft in the Irish server case, and more recently in a case challenging, the government's right to demand records from the cloud. We've seen Twitter and Facebook in various cases staunchly defending the rights of their customers and invoking the First Amendment and saying, in Apple's case, you can't compel us to write code that we don't want to write, and Microsoft is arguing that it has a First Amendment right to inform its customers that their data has been subpoenaed by the government. There's a similar case involving Twitter out in California, and I do think, as you said, it is important to remember there's a reason that in those cases they're standing up for the First Amendment, and that is that they do have a business interest in reassuring their customers. There's a lot of fear the part of customers. And here we sort of circle around on transparency, where customers fear that that their information and their data is being accessed by the government without them even knowing. And tech companies have a real interest in assuring their customers that they're not the ones who are turning over data, and in fact that they don't want to give away their customers' information. So when corporations say we're going to fight the government, they have a business interest in mind, and when they say in court, please seal our records, they have a business interest in mind. So I think in both cases, corporations are looking out for corporations.
So self-interest is the through line in all of those cases, and we're going to see a lot more of them, as you know, in the months and years to come as technology raises new legal issues. So Alison Frankel of On the Case, also published at Reuters, thanks so much for joining us.
Thank you so much. This was a great talk. Thanks.
You bet.